Hi, welcome to the video. I'm Dino Vera and I am a copyright lawyer from the Philippines. Today we'll talk about Raygun and her need to control her performance as a breakdancer. I've seen the videos and reports that Raygun, in her notoriety as the breakdancer from Australia that competed in the Paris Olympics in the breakdancing event, that she is stopping a club or a comedy club from holding Raygun the musical. And in fact, at this point, in December 2024, she has sent a letter, a demand letter to the club owner demanding 10,000 Australian dollars as a compensation for her hiring lawyers that sent the cease and desist letter. Now, I would like to give my opinions and comments about what exactly is the law behind what Raygun did. Now, as you know, and I'm sure if you haven't lived under the rock in the last year, Raygun is this Australian breakdancer who competed in the Paris Olympics in the brand new event of breakdancing. It is now, last year, it was considered an Olympic event, a medal event. Now, I haven't seen her performance per se, I just saw snippets of it. But again, everybody knows it was one of the strangest performance as a breakdancer. In fact, it's so ridiculed, it's made fun of, and I know last Halloween, costumes of her uniform was a hit. Now, does she have any legal right to her breakdance performance? Well, let's break down the law. And mind you, I have studied copyright law under U.S. jurisdiction. My master's from intellectual property is from University of San Francisco. And of course, I also am educated here in Philippine law. Now, per se, dance moves or choreography is a protected art form or work under copyright law, both here in the Philippines and in the U.S. But because it was done in the Olympics, there's a little bit of a gray area. Let me break it down for you. Now, usually a dance or choreography without any Olympic background or Olympic factors is only protected as a work if it is placed or put in a medium that is expressed, meaning it is in a medium that can be seen with at least the sense of sight. Therefore, if you see it live on TV, technically, it was expressed in a medium. But if it's a live event and there's no recorded version, technically, it is not protected because it was not saved in a medium. Now, also, because it was in the Olympic event, usually the Olympic organizers will declare anything done by any athlete in an Olympic event is owned by the Olympics. That I know is for sure because they have to sell the Olympics to the media, to media organizations, to TV or SAT or whatever broadcast they will do. They have to sell those rights to these broadcast companies. And therefore, the broadcast companies, it's going to be taped or recorded in a medium. Therefore, it is already considered a protected work that is owned by the Olympics. So, when Raygun danced her unique routine, it was done in an Olympic event. It's technically a sports event. Was it choreography? Well, it is still considered as choreography because the event itself was called break dancing. Now, if we say that it is owned by the athlete in an Olympic event, whether it be dancing or not, then there is a slippery slope argument that the gymnastics event, the figure skating events, even the swimming events, or even the moves in basketball, are they protected? Are they copyrightable? There is no definitive case regarding this, but it does stand that when a broadcast company pays the organizers, at least for the US, there's the NBA and the Major League Baseball, Once they pay their fee and they put it in their system, whether it be taped or on a digital file, the broadcasting organization would get to own that event. But it's under license from either the NBA or Major League. In this sense, Raygun's performance is owned, in my view, by the International Olympic Commission or IOC rather than Raygun herself. Because I'm sure as an athlete, she signed off those rights to the Olympic organizers so that they in turn can sell the performance to the broadcast organizations. So in that angle, I believe Raygun has no rights to her performance because she did it in an Olympic event and it was done in Paris. Of course, now we have to consider French law. Of course, what Raygun did was that her performance was done in Paris on French soil in an Olympic event. Therefore, again, I would like to say that because I'm sure athletes sign off on their rights to the Olympic event, therefore, I believe she does not own her rights to the dance or her routine and there could not have filed, or when she sent that letter to the comedy club in Australia, she had no legal basis because, in my view, and interpretation of the copyright law, she does not own her dance routine. Hi, please do me a favor and smash that like button. It'll help me a lot and it will trigger the YouTube algorithm. Now, if you have not yet, please subscribe to my channel. If you don't, my dog will eat this exam booklet and that student has to repeat his final exam again.